My name is Brendan Negron. I'm the pro se representative for this case. I would like to reserve 5 minutes for rebuttal.
All right, very good. And you're representing yourself, and you're not a licensed attorney.
That is correct.
Very good. Well, you have the absolute right to represent yourself, and I just want you to know that I'm pleased that you were able to watch the argument before you and the case before you, so you'll have an understanding of how we go, and we may ask questions or we may not. It doesn't indicate that we have any more or less interest in the case, but it just means we might have questions. But anyway, and the clock in front of you there will be green until there's about a minute left, and then it'll turn yellow, and then when your time up, it'll turn red.
I understand. Thank you, Your Honor. I do want to, before we begin, I would like to just correct the transcript, the record, as the transcripts that were provided to this court. They indicated that Eric Phillips from the law firm Hager & Phillips represented Brendan Negron. That is not accurate. Hager & Phillips and Eric Phillips represented the defendant, Andrew Roach. It was mentioned briefly in the brief that both parties had paid funds and received counseling and legal services from that firm, and that may have been a area of a conflict of interest that wasn't handled appropriate, that was brought up in the brief for conflict of interest and reviewable by an abuse of discretion. But I would like to focus on the main elements of the appeal. I just wanted to clarify that. The main elements for this appeal is an abuse of discretion by the special master in deciding not to grant the order of protection, which my position would be that it was an arbitrary decision that did render this case appealable based off of a abuse of discretion. In her decision, the special master, she did say that she wasn't saying that the petitioner did not have a basis for his petition in the first place about stalking. She mentioned that he may have believed that the behavior, which included but was not limited to the defendant coming by the petitioner's home, known residence, calculating where he would be, and trying to find and appear at these places, and recording over 100 Zoom calls to later review. She mentions that that type of behavior would, that may have let the petitioner believe he was being stalked. So she validated that there was a merit for bringing the petition. In addition to that behavior, she points out that the petitioner does, and he testified, I testified, and in the petition, that there is an element of fear, there is an element of harassment, there is an element of feeling intimidated. It was testified to, and it's in the petition. And in his testimony, the defendant's testimony on, I believe, page 156 of the transcripts, when he's asked, will the behavior continue, he answers absolutely. And in the case law of Laws versus Cafe, the assessment on that was that an order of protection, the assessment of an order of protection provision provides that stalking victims means any person, regardless of the relationship to the perpetrator, who has been subjected to, threatened with, or placed in fear of the offense of stalking. So when one party is giving an absolute that the behavior will continue, the other party is saying, I'm in fear of this behavior, and the special master in this case validates that there is a basis to be afraid, it is reasonable to be afraid. Applying that, those facts to the law should have rendered the order of protection granted.
Mr. Grant, the special master in this case also viewed the conduct in terms of the places he was at and what he was doing, Mr. Roach's behavior, as being reasonable. Why do you believe that was in error, the determination that his behavior was reasonable? Because that seems central to what the trial judge decided here in terms of saying, I'm not going to find this to be stalking because I think the behavior was reasonable. Why wasn't it?
Thank you for your question. To answer that, I think there's 3 points. One is she did not touch on the surreptitious recordings of the Zoom calls, which the defendant admits, and it's in the appellant brief on page 15 is confirmed that he records and watches these Zoom calls. That particular action was not legitimized. The one where he is at a place and she's calling that legitimate, I think that was a misapplication of the law, because essentially what's being legitimized is unlawful behavior. So if you're going to legitimize behavior, it should be in accordance to law, the law, and to be outside or on someone's personal property with the sole intent to record and gather documentation to intimidate, as the defendant testified, for the sole purpose of collecting data on someone's behavior. It just wouldn't be an appropriate, as I'm doing, an abuse of discretion to legitimize unlawful behavior in those senses that you bring up. And when it comes down to, would this person, the petitioner, need the order of protection, in Autry versus Autry, that case law, that stated that an order of protection is appropriate where there is sufficient evidence that the victim needs the protection available. And with the denial of this, there is no way to protect the petitioner, myself, from future actions like this. And to legitimize that means I have to endure those actions permanently. And I would also like to mention that the petitioner finding that there's a basis for the petition, or the special master finding there's a basis for the petition, if this is overturned, it does become a moot point about attorney fees. However, when there's the special master mentions that there's no evidence of the stalking proof on the children, but doesn't mention that there was an actual video of these surreptitious Zoom calls played at the trial level, and that the defendant admits to over 100 times recording surreptitiously Zoom calls between the father and his 3 kids, to which he's not a party of. So,
Mr. Negron, one of the trial court judges, or the special master's concerns here was also related to abuse allegations. And I wonder, on the form here, there's a box that's been marked that says this request is being made by a law enforcement officer pursuant to TCA 363619. The person on whose behalf this petition is filed consents in writing to file and signs here. And so that particular Tennessee Code provision does relate to domestic abuse. Are there any findings or determinations in this case related to the marking of that particular box on your petition? Because this wasn't presented by a law enforcement officer, right? And the petition, you presented this petition, not a law enforcement officer, correct?
I believe that I presented this to the judge at the building, the night judge, or whoever it may be, on the request of a law enforcement officer. And I think this is important, that the special master clarifies that there's no domestic relationship, there's no prior domestic relationship, and there's no children. And then in the same breath, almost out of the other side of the mouth, is saying, well, because there might be potential or upcoming custody. But by denoting those things, you admit that there is no way that either of these parties can ever take out litigation and petition for custody children that don't exist between them. And so the stalking allegations that show up in the petition are made after the defendant testified, which was on October 26th of 2023, to over 100 surreptitiously recorded Zoom calls. The petition comes in December of that year. So after the petitioner became knowledgeable of those recordings, then the petition was made with, again, what the special master said, a reasonable basis, and yet excluded that from when she applied a court cost or attorney fees. She said there was no basis, and she seemed to be focused on sexual allegations over the line of, I believe the line in its quote was, inappropriately touching the child, which is a vague line that has a wide scope and yet was purposely repurposed to mean sexual allegations that didn't appear in the petition. They weren't testified to. There was no allegations, and she seemed to find sexual allegations to be knowingly false, but they weren't mentioned, and then attached attorney fees due to those, which again, I would ask this court to reverse the trial court's decision to deny the order of protection based off the law versus Coffey setting precedent the special master did not provide an authority that set a standing or a case law that set precedent, so there was really nowhere to go off of that. And I would also ask if, in the alternative, the court decides to affirm that the trial court's decision to apply or award attorney fees be overturned as well.
All right, thank
That's all I
you.
have.
We'll hear from you further on rebuttal.
Thank you.
Good afternoon.
Good afternoon, Your Honors. I'm Jonathan Wardle. I'm here on behalf of respondent/appellee Andrew Nicholas Roach. I don't say what I am going to say next lightly. Mr. Negron made false allegations in his petition, and the trial court found that. He litigated those false claims between two trial-level courts. He continues now to pursue false claims, and even here in this moment, he has made statements that are not correct based on the record.
Counsel, are the knowingly false statements here and trial judge touches on a number of things related, for example, to sexual assault allegations that seem to be post-petition. In terms of the petition itself, are the false statements the stalking of the children? Is that the knowingly false statement that's being made, that the children weren't being stalked?
So the knowingly false statements are, again, they're numerous, and they have continued. There was what's in the petition, which is not the only thing the court looks at. The court looks at all the claims made. If you make false statements during the course of your testimony in support of the petition, that's also to be considered. Right? In the petition, he does make allegations about the children that are just not true. For example,
stalking of the children.
Not just the stalking. He says that they never. He says that they never. He puts their wrong address down. Says that petitioner did not have a relation. Not petitioner. That respondent, Mr. Roach, did not have a relationship with them. He does make claims of stalking. He alleges basis for fear, right? And then in testimony, more is brought out. We don't have all of that testimony because it wasn't provided in the record from the general sessions, but we do have testimony. And it's not just about the children either. The testimony at the circuit court hearing about vandalizing the car, which there's just no proof of that other than his own testimony, which the trial court clearly discredited.
Well, the fact that it's only his testimony doesn't mean it's false.
No, I said no proof besides his own testimony, which the court discredited. And Mr. Roach testified that that never happened. And we do have the pictures that Mr. Roach took on that one occasion. They're clearly taken from inside a car. There's nothing to say that, and even Mr. Negron does not say, I saw Mr. Roach vandalize my car. He said, I saw someone get out of Mr. Roach's car and my car was vandalized the next day. There's just...
In terms of allegations that are not in the petition, I wonder if you could address the language, and looking here at 36.3, 617, 2B, was false at the time the petition was filed. And that language seems to suggest to me that we're looking at it in terms of allegations that are being made in the petition, not subsequent statements. And I understand that there's some falsities in the petition itself that you're asserting, and that may make this question moot but you've also argued these assertions with regard to sexual abuse, and that seemed to be some concern to the trial court judge here. Aren't those subsequent statements that aren't false at the time the petition was filed?
I think my answer to that, Your Honor, would be if you have false allegations in a petition, then at that point, attorney's fees can be awarded, especially when false allegations are permeated throughout the proceedings. Otherwise, you could simply do what kind of happened here. We make these false allegations, we litigate them through the General Sessions Court, we get up to circuit court. At the beginning of the hearing, say, never mind, we're going to drop those false allegations. Now you can't get attorney's fees. And that's just not what the law is. I think it's you make false allegations in the petition, and now you can look at the whole panoply of all the falsities all the way through the end of the hearing. I think that would be my answer. If there were no false allegations in the petition, we might have a different situation.
In terms of disqualification of counsel, was any motion raised before the circuit court, or was it exclusively before General Sessions?
There was a very tiny bit of discussion in the circuit, but no motion raised. It was exclusively in the general sessions.
Is that issue waived then in terms of by failing to raise it before the circuit court, the disqualification issue, do you have to raise that again before circuit?
This court could certainly find that it was waived, and in the event that it doesn't find that it was waived, there's just the record is insufficient, and so it would be waived for that reason also. If I may, I do need to correct one part of my brief that may bear, and it also relates to some of the statements that were made here. In my brief, I said that there were 7 issues. And it turns out, rereading, he brought up 8 instances. And his brief on appeal doesn't mention the Zoom issues. The Zoom issues were not an issue below. They were testified about, and that was that Mr. Roach, what was claimed below was that Mr. Roach watched the Zoom sessions between Mr. Negron and his children. Mr. Negron's children live with Mr. Roach, who is engaged to their mother. So the claim was Mr. Roach watched the Zoom sessions. I don't know that that would be improper, but Mr. Roach testified, no, I don't watch them. I record them and then I watch them later to make sure there's nothing wrong. I don't think there's anything wrong with that. But there was no claim below that, oh, this constitutes stalking. All right? There was no testimony that I'm aware of that talks about the number of times. And so when he's saying hundreds, there's just nothing in the record about that. There's no testimony about that, no proof about that. What he talks about in his brief is taking photographs on 2 occasions. And he says in his brief that Mr. Roach admitted to taking photographs on 2 occasions and testified to that, and it's just not true. He admitted that he took photographs on 1 occasion, June 1st. The part of the record that Mr. Negron cites to is page 170, where on page 169 and 170, there's discussion about June 1. And then there's one question about August 3rd, where the question is, what about August 3rd, 2023? They had said that you had gotten out of your car. Answer, 100% not true. That's all that's said about August 3rd. Next question. Were all the pictures that you took from inside the car? Again, the context of this is we've been talking about June 1, except for that one question. All right? And Mr. Roach answers, yes. He doesn't say, yes, I took them on multiple occasions. Yes, I took them on 2, right? This is the pattern that Mr. Roach has had to defend against this whole time. We're going to cherry pick and mislead and misrepresent and make false allegations, and he's continued it before this court. That is why the trial court discredited him. It's why the trial court denied the petition, and that's why the trial court awarded attorney's fees, because of this pattern of falsehood, starting with the filing of a petition and continuing all the way through. And we would ask that this court...
Speaking of attorney's fees, how did the trial court come up with the figure $11,000 some odd dollars?
That was from an affidavit, and I believe that affidavit is in the record. That was submitted by...
I think there's affidavits of 6,000 some odd and 7,000 some odd, but not 11,000 unless I missed it.
I will be honest, I could not, off the top of my head, I cannot recall where that number came from. But it's our request that this case be remanded for attorney's fees on appeal for the correct calculation, and if this court would like the court to do a more accurate calculation of the attorney's fees, that would be absolutely appropriate.
What's the basis for the attorney fee award on appeal?
That is the law allows, and I cite the law in my brief, when you're allowed the attorney's fees below for the false petition, it goes all the way through for the entire litigation. This appeal is still part of that litigation. And it goes to what I said earlier. You can't make false claims in a petition and have to litigate them a little bit and then say, never mind, I'm not going to litigate those anymore, and you don't get any attorney's fees for having to do this.
There's an underlying policy argument that's being advanced here by Mr. Negron in terms of the complications and difficulties of Mr. Roach essentially traveling around various places, showing up, watching what he's doing, and whether what the special master has done here is essentially endorsing that behavior, and that there may be there's some real problems potentially with that. What, taking the view that the special master took the view that that was reasonable, why is that reasonable for Mr. Roach to be traveling around observing? And I have to say that sort of as a default, it seems sensible that these two parties not really be interacting with each other to a great extent. Why is this a reasonable behavior?
Well, to begin with, I would, if Mr. Roach had been my client at the time, I probably would have said, just stay away. That said, the proof in the record of when he saw Mr. Negron is not all these different times. The proof is 5 times in court. Well, 4 times in court, 1 time dropping off for supervised visitation, which there's just nothing that's anything like stalking about that. There's an incident where Mr. Negron testified below. On September 1st, he saw Mr. Roach. No testimony about where it was, what happened, how he saw him, if Mr. Roach even knew Mr. Negron was there. It's just, I saw him on September 1st, so we don't know what that's about. There's the testimony about June 1. That's the only one that we have about he's going around looking for, well, no, that's not true. There's going around looking for Mr. Negron. And then August 3rd, Mr. Roach admitted that, yes, I drove by his house and I turned around in the driveway. That's it. 2 incidents. One where he drove by a place to look for Mr. Negron's car, not even to interact with Mr. Negron, just went and looked for his car because he knows sometimes he's here doing stuff he shouldn't be doing. And they're in the middle of this protracted litigation involving the children. And then when he doesn't see him there, he drives away and sees Mr. Negron parking away from his girlfriend's house and thinks, this is weird. He's getting out of that car and walking to his girlfriend's house. Instead, I wonder why that is. Takes pictures of his car. That's it. They don't interact.
Why is that reasonable? Let's say it is, and putting aside the court hearings, and putting the court hearings, got it. And the other incident, why is that reasonable? What's he doing driving around and turning around in his driveway? Why is that reasonable behavior?
Well, the turning around the driveway, again, it's not a threat. It's not even clear that Mr. Roach knew that Mr. Negron was there on that occasion. The question as to why it's reasonable just goes to the case law that I cited in my brief and that the court relied on, which says when you're in the middle of these types of proceedings, these child custody proceedings, it is okay. You have a legitimate basis to look for what the other person's doing. If he had, I understand the concern could be if we're talking about 10, 15 times, or if we're talking about we're getting out and interacting with you, if I'm getting in your way. But here, I have a right as a person to drive on the streets, and I can go where I know you're going to be and take a picture of your car. It's
so
okay.
You're understanding the reasonableness endorsement here. Mr. Negron raised on in his argument here the idea that he permanently, Mr. Roach, could be following him around forever. Your understanding of the reasonableness view of the trial court judge here is that this is limited in time in terms of these proceedings that are going on, and it's not sort of an open-ended endorsement of Mr. Roach's behavior as being reasonable going forward.
Correct. And to speak to what Mr. Roach actually testified about going forward, the testimony. Question, this is page 156 of the hearing transcript. Question, Mr. Roach, do you plan on continuing to follow Mr. Negron? Answer, I don't follow Mr. Negron, I never have. So these happenstance contacts that have happened over the past year, this following online, that's not following him in your opinion, but is that going to continue? Answer, I think it's going to be important going forward based on Mr. Negron's mental health and his activities that we continue to understand what it is that he's doing and what he's up to, absolutely. Again, the unique circumstances of this case where you have him locking himself in the house until a SWAT team comes with the children, the violations of so many issues during supervised visitation, the violations on the Zoom visitation, the protracted proceedings. This isn't a typical situation, and he's just trying to protect the children. Would you and I do it differently? Perhaps. But did he do anything illegal or anything that constitutes stalking? Anything even that a reasonable person would find harassing? No. He attended court, he dropped the children off supervised visitation, he took pictures of a car on one instance and drove by the house another time. That's all the proof in the record. And again, we go back to the petition that Mr. Roach had to litigate, alleged so many different things that's not what was alleged in the petition. What was alleged in the petition, and it's filed under seal, so I won't say it directly here, but it's completely different. So for all those reasons, we would, I should ask if there are any questions about the evidentiary claims or anything like that. They weren't addressed. All right. We would ask that this court affirm and that it be remanded for calculation of reasonable attorney's fees, including fees on appeal.
All right, thank
Thank
you,
you,
sir.
Thomas.
Mr. Negron, you have time for rebuttal.
To respond to opposing counsel's claims. So the claim, there's a few claims I took note of. One was the address. I think it's important to know that the statute for these attorney fees are knowingly false claims. the petition was served not at the address to which my children reside. So to say, oh, he resides with the kids, he was served at his known address, not the address that they claim he resided. So these ideas that there's knowingly false because there's a difference of opinion, and that's the basis for granting attorney fees, is why we were there to litigate. I believed I had a basis for stalking with the Zoom calls. If they want to litigate a difference of opinion, then they can, and that's what they were doing. But to say that that's a knowingly false claim, which is admitted in the defendant's testimony, and it was admitted in the testimony on a hearing on October 26th of 2023, for that to somehow knowingly be false, that doesn't make my position. It would be that would not be a knowingly false statement. To touch on where this $11,000, there was an affidavit submitted by Eric Phillips that I believe it was an affidavit that was contested to because of what it declared the job, him doing his job in representing what he did. And there was billing errors in it, so it was contested, and I believe that's where the $11,000 came from. On the allegations of when Mr. Roach was in front of my property, it shows that there is a pattern of behavior for him to come around my property, as noted. There, on August 3rd, he testifies to, and it's on page 138, and it's on page 144 of the transcript, where he says, the question is, were you at Mrs. Carr's residence on August 3rd, 24th? I believe that was the day I turned around in her driveway. He goes on to say he turned around in the driveway because of convenience, and that's about 10 minutes away from where he lives. After the matter's pressed a little more, he says, actually, I was there to make sure I can get behavioral information on the petitioner in this case. So to allege that it's for the kids and to shelter yourself because you're just concerned about the kids, and then when you go down that, it's determined that you're actually just there because you want data, whether it's data for litigation and child custody. But he also testifies that on 149 in the transcript, that he contacts the petitioner's probation officer. And in doing so, what he's doing is he's taken it upon himself to put himself in a position that he's calculated the petitioner to be, whether it's a bar, at home. He puts himself in an experience. Then he gets to testify with no grounds on, no loyalty to any ethics. He's not a private investigator. He's the paramour of my ex-wife. So he gets to put himself into an experience, testify to whatever he wants to allege, and a lot of these violations of probation are alleged violations of probation that never materialized into anything. So he can allege a violation of probation in the hopes to incarcerate his opponent or his adversary in this manner, which is why it would become unnecessary and unreasonable to allow this man to continue to put himself in a position that he's calculated I would be, then to make up whatever he wants to allege, whether it be he was drinking, gambling inappropriately, no arrest, no violation of probation for either one of those actions, but to allege it as a material thing for custody, or to say that that behavior, because I filmed it or I documented it, means X when it doesn't. He does take pictures on August 3rd outside while he's on the driveway. He admits to that. He also takes pictures on June 1st of 2023. He admits to that. Both of those were submitted, or they were reviewed, whether it was in this case or the one prior to it, or the one on October 23rd, where he divulged the information of how long, which was for 3 years, how long this behavior has been going on. And that's all I have for you. If there's any questions, let me know.
All right. Thank you, Mr. Negron and Mr. Wardle. We will take this matter under advisement, and Mr. Negron, we will render a written opinion that will be forwarded to you from the clerk's office in some point in the future. That concludes the afternoon docket.